If you are a Canadian employer and you have employees who are on work permits, then the Canadian immigration authorities could come knocking one day seeking an immigration audit, an inspection to ascertain whether or not you, the employer, have been conforming to the conditions that would have been imposed on the work permit at the point it was issued. And if it turns out that you've not been conforming, then there could be severe penalties for you, the employer, and potentially for the employees. When you are able to successfully secure work permits for your employees under one of the immigration programs that do not require you, the employer, to apply for an LMIA, a labor market impact assessment, then what that means is that at some point down the road, an immigration official may reach out requesting an audit of your files and your processes to determine whether or not the conditions that would have been imposed on the work permit of a particular employee or employees, whether or not those conditions have been upheld by you, the employer. Okay? So when an employer is applying for or is wanting to apply, or rather is wanting to assist a prospective employee, a foreign national, to apply for work permit inside Canada under one of the LMIA exemptions, then that employer typically needs to submit what's called an offer of employment, okay? So this is where the employer indicates to the Canadian immigration authorities in this offer of employment that they will be what salary the employee is going to be paid, and indicating that the employee's salary is going to meet what is called the median prevailing wage for the location in Canada where the employee is going to be. The offer of employment will also outline the benefits that the employee is going to be receiving. It will also indicate the types of duties that the employee will be performing inside Canada, and so on and so forth. The physical work location in Canada where the employee is going to be, and these types of things. All of these will be indicated inside of the offer of employment. And therefore, the information entered into the offer of employment is really what the immigration authorities are going to be using to assess whether or not you've been meeting the conditions that would have been imposed on the work permit. So whatever conditions were imposed would have been guided by the information indicated in your offer of employment. For instance, whatever salary you would have indicated in the offer, the immigration authorities will want to know that the employee was being paid that salary amount, not less, right? And not substantially more than what was indicated there. The authorities will want to find out that. The authorities will also want to find out during this inspection whether or not the employee was performing the duties that you indicated you wanted the employee to perform. If it turns out that the employee was performing other duties, or duties that might have been performed by a Canadian citizen or Canadian permanent resident, then it could be found that your business would have been in breach of the conditions that would have been imposed on the work permit. And so what happens is the authorities will request specific information from your company to ascertain whether or not these conditions are being upheld. So they may ask for copies of your payroll statements for a specific period of time to assess the salary that was paid. You know, they may ask about the job duties. They may ask to see HR type information outlining the kinds of benefits that the employee is enjoying to ascertain whether or not you've been living up to the conditions on the work permit. If it is determined that your company was in breach of the conditions, then there are penalties that may be applied to your business. You know, the penalties may take the form of a warning from the immigration authorities, or it could be a monetary fine, or depending on the severity of the breaches, it could be even a ban for your business from utilizing the immigration program or similar immigration programs for a specific period of time. And even in some severe instances, a breach could lead to the revocation of an already issued work permit to your employee or employees. So an immigration compliance inspection is something that, as a business owner and as an employer of foreign nationals, you will want to bear in mind. These are, we have assisted other clients with inspections on multiple occasions. So these things do happen. And so as an employer, you want to ensure that you keep proper records and that you are aware of what the conditions are that would have been indicated in the job or in the offer of employment. And lastly, that ensure that your company is continually in conformance with those conditions. All right. So I hope you found value from this video. And as always, remember to like our video, subscribe to our channel, and check us out on our website at go.gooselaw.com. Thanks. See you again.